Well, staying in the Western Cape, the High Court is expected to hear an application by suspended Public Protector Busisiwe Mkhwebane on Friday. She wants to have an order of that court enforced that found that her suspension was invalid, a suspension by the President. The court had found on Friday last week that there was reasonable grounds to say that the President was perhaps conflicted in announcing that he was suspending Mkhwebane just soon after she'd sent him questions related to the Phala farm scandal. That's a robbery that took place at the President's farm back in 2020. The impeachment process is also going on in Parliament, where Mkhwebane's legal team has already said it will not be able to participate for much of this week because it's going to approach the High Court on that earlier issue of her suspension. Let's pull it all together now. Bring in Professor Pierre de Vos with the UCT, the University of Cape Town. Prof, a very good afternoon to you. Thank you so much for being with us. Advocate Dalimbofu said, speaking of the inquiry, that this is probably the biggest thing to happen in the legal sphere. Is he right?
Well, there's been bigger things. Whether this is big or not is not really that important. I think it raises interesting and important legal and constitutional questions. But of course, maybe the interest is really more in the political arena than it is in the legal arena.
And just how married legally are these two things that are quite separate, the suspension of the Public Protector and the inquiry that's happening in Parliament? Because every once in a while they are pulled together, aren't they?
Yes, so the two things are separate issues. So the impeachment inquiry is going on. The suspension, usually a suspension in this kind of case is done to remove the person who's being considered for removal from office from the office, so that they cannot interfere, so that the legitimacy of the organization can continue and so on. And that is a different process than whether the person then ultimately would be removed. It's like a precautionary suspension. It happens all the time in the workplace as well.
Is it inconceivable, though, that whatever, let's say, if Advocate Mkhwebane gets victory in challenging her suspension, that could torpedo, perhaps even just stall the work of the inquiry in Parliament, do you think?
It will. This whole fight is happening, as I suggested earlier, in the political realm and in the legal realm. Ultimately, the Public Protector, unless she can string it on until the term comes to an end, she must be removed, and she will be removed. But Mr. Bofo and the Public Protector are fighting a political fight for the hearts and minds of people. And so if she returns and the suspension is lifted, then obviously that will be a huge political victory. I don't think there's any grounds that might happen, because the Constitution is clear. The order of the High Court is not going to be enforceable until such time as the Constitutional Court either confirms or doesn't confirm it. It's clear. I know the Public Protector's lawyers argued differently, but there's a long line of cases that said if conduct of the President must be that is invalidated constitutionally must be confirmed, and this should be broadly interpreted. So yes, it would be very surprising if the High Court overrides or overlooks that provision in the Constitution.
But what's going to be crucial with the Constitutional Court either rubber stamping what the High Court said or going against it is the length of time that we're going to have to wait to hear what it decides, no?
Yes, so this is, the High Court heard the matter in a matter of urgency. So one assumes that the Constitutional Court process will then also run on an urgent basis. So it will take a month or two perhaps, and not 6 months or a year as it would, or a month or 2, 3, and not a year as it normally does.
Legally, do you see any complication, so to speak, if we had a scenario where the suspension was indeed lifted and you had a Public Protector who's reporting for duty Monday to Friday, yet is facing an ongoing inquiry that could result in her removal?
Well, there's an issue of legitimacy, of course, for the office of the Public Protector. Somebody facing all these complaints, and the evidence against her is quite devastating. On the other hand, we don't know what the public protector would do if she goes back to the office, whether she will use the power of that office to try and to destabilize the process or torpedo, sabotage the process. So we don't know. And of course, there's always the option, if you have unlimited funds, to make other applications to the court for many other reasons, like former President Jacob Zuma is doing. So who knows how long this battle is going to last.
I was listening to Advocate Dalimpofu, in fact, reading a piece published earlier where he was on radio confirming that he's now been instructed to put forward an application for the recusal of the chairperson of that inquiry looking into Advocate Mkhwebane's fitness to hold office on the grounds of bias. Not a new allegation. Mpofu himself is facing calls for investigation for allegedly threatening the very same commission chairperson, not commission chairperson, but committee chair. It's a muddy situation. But is there sufficient grounds to build a case to say that Mr. Jantyi has indeed, as committee chair, been biased and disadvantaged, Mkhwebane?
Yes, this is part of the judicialization of politics. And so people don't always understand that there's a different requirements for fairness, impartiality, and so on in, say, a criminal case. There are strict rules there. That is very different from what happens in Parliament. Parliament must make an assessment and make a finding that is going to be rational. The procedure must be fair in the broad sense of the word, but it is not the same as a judge. Mr. Jantyi is a politician. He is elected by voters to be a politician there. He must run a fair process, but he is not required to be like a judge because he isn't a judge, he is a politician. As long as the process leads to a rational decision at the end of the process and the procedure itself is not obviously trying to stop somebody from having, say, the public protector from having her say. If she was prohibited from testifying, obviously, that would be egregious.
Finally, on Advocate Mpofu's, shall we say, controversial performance yesterday during the committee hearings where he basically said to the committee chair, I'm senior to you in age and in many other ways, and basically said that he will pay, perhaps at a later stage, for the way he's treated him on that platform. And when he was asked if it was a threat, he said, yeah, without hesitation. Is there any possible route outside of Parliament that can be pursued against him as a legal practitioner to perhaps hold him accountable?
Yes, the code of conduct, actually, of legal practitioners says that the legal practitioners are supposed to be respectful and so on. So somebody might complain to the Legal Practice Council. We know that a previous complaint, they dismissed it. But this seems to be a little bit more serious. So it depends, of course, if somebody is going to make such a complaint that Advocate Mpofu had acted in breach of his basic duties as an advocate.
Professor Pierre de Vos, thank you for your time as always.